God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Costa, Durkin, and Chief Justice Kim presiding.
Good morning, everyone. Is the petitioner ready?
Yes, Your Honor.
And the respondent?
Yes, Your Honor.
Mr. Vasquez, do you want to just go ahead and introduce your team?
No.
Yes, Your Honor. My name is Marc Vasquez, appearing on behalf of the petitioner, Neptune Candy Company, and my co-counsel is Elliott Brooks.
And my name is Pierce Ilmer, appearing on behalf of the respondent with co-counsel Doug Brown.
Thank you. If the petitioner is ready, you may proceed.
Thank you, Your Honor. Good morning, Your Honors. Chief Justice, Associate Justices, may it please the court. My name is Marc Vasquez, and I, along with my co-counsel, Elliott Brooks, represent the petitioner, Neptune Candy Company. I will discuss why Neptune Candy Company's website, neptune.shop, is not a place of public accommodation under Title III of the ADA, and my co-counsel will discuss why the respondent cannot succeed on a Title III claim under the intangible barrier test. I'd like to reserve 1 minute of my time and 1 minute of my co-counsel's time for rebuttal, please.
You may.
Thank you. The constitutional duty of the judiciary is to interpret and apply the law as written by the legislature, not to update the law on policy grounds. Thus, this court should affirm the 13th Circuit on the first issue for 2 reasons. First, the plain language of Title III unambiguously limits the phrase place of public accommodation to physical locations. Second, even if
whether something is ambiguous or not, it appears to be depending on which side you're sitting on. I mean, if you look at Judge Gibbs' concurrent opinion, it sounds very compelling, and he seems to think that there is some ambiguity here. What are some of the flaws of Judge Gibbs' concurring opinion?
Judge Gibb does not take into account the ordinary meaning of the word place, as a majority of circuits have taken into account. Instead, Judge Gibb thinks about the general everyday use of place as maybe referring also to online locations. But, Your Honor, we have a very rich vocabulary for virtual spaces. We refer to feeds and pages and whatnot, but none of that language is in the statute. Congress used the word place, which ordinarily refers to physical locations, and supports that ordinary meaning with 54 examples of physical entities in section 121817. So Judge Gibb does not read the statute, but rather updates it on policy grounds to include online locations.
May I ask on that point, if I may, counsel? So you say that we would be updating the statute's language, but haven't we recently decided a case where the term sex included transgender? And really, isn't this just a case of Congress choosing a word, not defining it specifically, and then allowing the courts to fill in the gaps over time as the meaning of that word might change? Doesn't Congress take that risk when it uses a word like place?
Not in this case, Your Honor, and this case is distinguishable from Bostock versus Clayton County, because as this court held in Bostock, it is impossible to discriminate against someone on the basis of sexual orientation without somehow taking into account sex, which is the word that Congress used in the statute. But here, physical places are categorically distinct from online locations. It ordinarily and primarily refers to place, as the majority of circuits have found.
I guess my question is, did Congress have that in mind when it passed the statute?
Yes, Your Honor, and another reason for this court, excuse me, Your Honor?
How do we know?
Because of the list of 54 physical entities, and Congress made no allusion to online services. And even when it amended the ADA in 2008, it did not update the language of the statute to include online services. It's important also for this court to know that Congress is currently working on this issue, which is another reason for this court to affirm the lower courts and allow Congress to update the statute. In February of 2021, Congress introduced a bill called the Online Accessibility Act into the House, that's HR 1100. And so Congress is currently addressing the issue, which is another reason for this court not to update the language of the statute. But to return to the statutory language, Your Honors, in addition to adopting the physical meaning of the word place, this court should affirm the majority conclusion adopted by the 3rd, 6th, 9th, and 11th circuits that the list of public accommodations in section 121817 is limited to physical entities. The minority.
But the act itself doesn't define place, like Judge Gibb points out, right?
It does not define place, Your Honor.
And you say the ordinary meaning of place is a physical location. And yet if you were to say Judge Ketanji Brown Jackson now has a place in history, that certainly wouldn't refer to a physical location, correct?
Yes, Your Honor, in that phrase, it's not a physical location, but read in context in the statute, given the list of 54 entities, of which only 2 terms are disputed in this case, it is more proper to read it as limited to physical locations rather than—
Congress certainly could have said physical locations in the act if it wanted to. Going back to Justice Costa's question, didn't they deliberately use general terms so that it can grow with the time?
Congress did say in the congressional record, Your Honor, that the statute should keep pace with rapidly changing technology, but it did not enact that language or that imperative as law. What it did enact is the phrase place of public accommodation and an extensive and exhaustive list of 54 physical entities using words like establishment, which recurs throughout the definition, a motion picture house in subsection C, and so on.
Counsel, the list of 54 various entities or locations, is that exclusive? Is there anything in the statute that says these are the only ones, or have other places been interpreted to add to that list of 54, which are they simply examples or are they exclusive?
This is an exhaustive list of categories, Your Honor, but at the end of each subsection, there is a general clause that contemplates that other similar kinds of physical entities would fall within the ambit of Title III. For example, one of the disputed terms in this case, or other sales or rental establishment, would encompass objects and entities similar in nature to the preceding terms, such as a hardware store or shopping center. And given the physical nature of the preceding terms, Neptune.shop is not a sales or rental establishment. To turn briefly to the DOJ, Your Honors, Congress delegated the power to enforce Title III to the DOJ in 42 U.S.C. Section 12186B, and the DOJ's binding regulation to enforce Title III supports petitioner's reading of the statute. In 28 CFR Section 36.104, the DOJ defines place of public accommodation as a facility operated by a private entity whose operations affect commerce and fall within at least one of the categories in Section 121817. Section 36.104 not only omits any reference to websites, but defines facility in exclusively physical terms. And this definition is important for this court's interpretation. The DOJ writes, facility means all or any portion of buildings, structures, sites, complexes, equipment, rolling stock or other conveyances, roads, walks, and so on, Your Honors.
The DOJ's reading of the act isn't binding on us. Would that be fair to say?
Yes, Your Honor, because the statute—
if DOJ got it wrong, we don't have to repeat the same mistake.
The DOJ regulation is not binding upon this court because the statute is not ambiguous. However, it should hold significant persuasive weight because, as of now, the DOJ has not promulgated any standards that are predictable and that would give businesses fair notice for how to, in good faith, comply with Title III. As of now, the DOJ has promoted the YCAG 2.0 standards in some settlements with businesses. However, even if a business complies with YCAG 2.0 today, because of the constantly evolving nature of YCAG, tomorrow the very same business is subject to suit from another ADA tester requesting YCAG 2.1. So this court should allow Congress to hold extensive hearings, hearing from all of the parties with an interest in the reach of Title III, and then set equitable and stable and comprehensive standards to make sure that disabled persons have full and equal enjoyment of online spaces.
May I ask you, so you mentioned that the Department of Justice is charged with administering the statute, and they've passed a binding regulation that defines this term place of a public accommodation. Have I got all that correct so far?
That is correct, Justice Costa.
Are you telling me that we have to give deference to the Department of Justice's decision if we found place of public accommodation to be ambiguous?
If place of public accommodation is ambiguous, your honors would owe Chevron deference to the DOJ's reasonable interpretation of Title III, and that reasonable
Is that regulation being enforced in this case? Is that issue really in front of us in the summary judgment action?
Not quite, Your Honor, and it is merely—
Regulation is not being applied in your case, right?
No, Your Honor, but it is indicative of the reach of Title III because the DOJ, which is enforcing the statute and is interpreting the statute, is interpreting it in exclusively physical terms. So this court should not expand the reach of Title III when the DOJ, which is the enforcing agency itself.
And my question is that part of the question presented before our court today, and perhaps it's an error in which would you agree that maybe the case should be dismissed as improvidently granted because we should have included the Department of Justice and the challenge, if you're challenging or if part of your challenge is whether or not that regulation should be upheld, shouldn't the department have a say in that?
Yes, Your Honor, and that is why this court should allow Congress and the DOJ to address this issue because Congress, again, is already working on the Online Accessibility Act, and Congress can work in tandem with this enforcing agency to generate the most equitable solution. This court only needs to affirm the lower court's reading that the current text of Title III as currently written does not apply to online websites.
What is the relief you're asking us to order in our order in the case, please?
We ask for the first issue for affirmance of the lower courts and for granting summary judgment because as to the first issue, commercial websites do not fall within the ambit of Title III, and so there are no genuine disputes of material fact on the first issue. And as my co-counsel will elaborate on the second issue, there is also no genuine dispute of material fact there because Neptune complied with Title III through a sufficient auxiliary aid, namely the customer service line as seen on page 5 of the record. It is a sufficient auxiliary aid, as my co-counsel will elaborate, because Ms. Albert could have accessed all of the information that she sought on Neptune.shop by calling the customer service line, but she chose not to. To turn to the legislative history argument, Your Honors, although the internet was in its infancy when the ADA was adopted in 1990, when Congress amended the ADA in 2008, it added no reference to the internet or websites. But by 2008, many businesses were already conducting their services exclusively online. eBay was founded in
Mr. Vasquez, you're accepting the premise that the word place refers only to physical locations, right? Because if that's not true, there was no reason for Congress to do any kind of updating in 2008 as to whether it should include web pages. So it really comes down to the ordinary meaning of places, correct?
Yes, Your Honor. And Congress could have amended the ADA and updated it in 2008, but it chose not to, even if the circuit courts, in fact, the majority of circuits, were interpreting place in the way the petitioner is interpreting it. The 3rd, 6th, 9th, and 11th circuits, the 3rd, 6th, and 9th circuits had already issued rulings that interpreted place as referring to physical places, yet Congress let that interpretation stand. And now Congress is working on the issue, Chief Justice, and so this court should allow Congress to expand the reach of Title III, having all of the parties heard and taking into account all of the variables, because this court is limited to the facts before it.
Can we really view inaction by Congress as a tacit approval of the position you're taking?
Not quite, Your Honor, and there could be an argument for congressional acquiescence with the majority view, but that is not the view that petitioners. I see my time has expired, Your Honor. May I briefly conclude my answer to your question?
You may.
Thank you. There may be an argument for acquiescence, but petitioners ask this court to affirm the lower courts and to allow Congress to finish its work on the Online Accessibility Act and not step in the place of the legislature. Thank you.
Thank you. Mr. Brooks?
May I begin?
Oh, I'm sorry, Ms. Brooks.
No worries.
You may
Good morning, Your Honors. Chief Justice, Associate Justices, may it please the court. My name is Elliott Brooks, and I represent petitioner Neptune Candy Company. I will be arguing why Neptune.shop does not qualify as an intangible barrier to Neptune's Westridge store, nor does it have a sufficient nexus to the physical store location. Questions of accessibility are imperative. However, it's this court's duty to balance that need for access with the resources of the courts and businesses, statutory language, and legislative deference. With this in mind, this court should reverse the 13th Circuit Court of Appeals decision on the second issue and hold that petitioners did not violate respondents' Title III rights under the ADA for the following two reasons. First, this court should adopt the intangible barrier approach rather than a nexus-based approach because it best aligns with the ADA's language as it stands. Second, even if this court adopts a nexus-based approach, petitioners still prevail because the nexus between Neptune.shop and the Westridge store is insufficient.
Ms. Brooks, is it a matter of semantics? In other words, if in fact the store, I think it's the Westridge store that actually sells candy in a physical location, if one were to say that this particular store is offering online experience, right? Online experience that is a little bit different than the actual in-person experience. And if so, isn't that part of a service that's part of the public accommodation, even if we were to assume that it has to be a physical location?
The difference in the store offering an experience, they may be different from the online experience, is speaks to one of petitioners' points to the reason why there is not a sufficient nexus, because it does inherently offer different stock options as seen in the record on page 5. Neptune.shop offers customers the ability to order bulk candy orders, customized candy orders, and specialized candy orders. However, none of those options are available in the in-store experience. This demonstrates one of the reasons why Neptune.shop is not integrated with the physical store. The other reason why there is not a nexus and why it has not been fully integrated is because, as seen on the record on page 3, the Neptune.shop processing feature connects only to the Westridge plant, which, as stated in the record on page 3, is not open to the public, but rather a private warehouse. This is important to note because the statute requires a commercial website, if it's to be under compliance with the ADA, to connect to a place of public accommodation. And in this case, that connection is not prevalent. Returning back.
I don't know. I think, the distinction you're making that in-person experience may be different than online experience seems to bolster the respondent's position that people with disability, especially the respondent, wouldn't necessarily be able to enjoy the same experience that others do. And for example, and I realize what you're saying is that there's no nexus, but what if the store has a sign, visit us on Neptune.shop? Isn't that service provided by the public accommodation?
There would need to be more facts, Chief Justice Kim, to establish that that would be a service of the place. For example, there would need to be at minimum, processing feature that if our orders were ordered on Neptune.shop per se, they would be able to be picked up or acquired at the Westridge store. That's not the case here. All of the orders that happen through Neptune.shop are individually processed at the plant. That's the only way that customers are able to get their orders on through the online website. So technically, if the Westridge store was to shut down today, that would not impact Neptune.shop's orders at all. And that's a very important distinction to draw, because unlike the cases of National Federation of the Blind versus Target or Robles versus Domino's from the Ninth Circuit, all of those cases connect to the commercial physical location. So in the Target case, those orders that were happening on Target.com were able to be picked up at the Target location. That's not the case here.
Is the record fully developed enough to make that conclusion, or are you asking for a remand for further development of the facts?
As my co-counsel mentioned, Ms. Albert has not demonstrated enough genuine issues of material fact to succeed past the motion for summary judgment. And that is primarily for three reasons. First, the customer service line, which as my co-counsel mentioned, does serve as a proper auxiliary aid under section 12182, section B2A3, which is codified in the statute to allow businesses to have the flexibility to ensure that they provide effective communication for disabled individuals. The other two reasons are what previously were noted to Chief Justice Kim, which are the fact that the plant is a private location. It does not connect to a public location. And the stock options are different, which ultimately demonstrate how it is not fully integrated.
When you say stock options, you mean inventory, right? Not like corporate stocks.
Correct, Justice Costa.
So the inventory is different at the plant than it would be at the store.
Correct. And moving into more of the analysis with the intangible barrier test.
Can I ask a question? I apologize. What's the practical impact of our affirming the 13th Circuit? What does that do to your business? What does it do to other courts who will have to interpret this statute for a variety of different websites across the world, across the United States at least? What is the practical impact?
The practical impact, Justice Durkin, is great for three reasons. First, there are 32.5 million small businesses in this country, which comprise 99.9% of businesses in total. Website compliance can range up to $10,000. So if this court is to adopt the broad nexus test, what could be implicated is a potential $325 billion investment just for website compliance pertaining to visual disabilities.
But that's not our fault. We're not the ones that make the law. That's Congress's fault. They should have thought of that. And it sounds like they may be thinking of it now. But if the law is that they have to comply, then they have to comply, right?
Your Honor, this is the exact reason why petitioners ultimately urge this court to give this issue to Congress and the DOJ, because as Your Honor mentioned, as well as my co-counsel, HR 1100 is currently being assessed and debated by Congress, as well as recent DOJ guidelines being released as of March 18th, 2022, that demonstrate that this issue is something that is on the top of mind of the legislature, which is the proper body to handle this issue.
Aren't we charged with doing our best to answer the questions that come in front of us properly, rather than simply saying, we just don't know, we should give it back to Congress? I mean, that's what it sounds like you're saying.
Your Honor, yes, this court is in a position to make sure that there are policy and overall big picture effects that help life in this country to become.
I respectfully disagree. Isn't it our job to do a very simple thing generally, which is just read the statute and say what the law is? We're not policymakers. Wouldn't you agree?
Yes, Your Honor. My apologies if that was misconstrued.
No, that's all right. I don't mean to criticize counsel. I know we're just doing our best jobs all around here. But when I look at Title 42 USC Section 12182A, the general rule, it seems like a pretty broad rule that Congress wants courts to look at. I mean, aren't we supposed to say everywhere where we can correct a past wrong by allowing for the full and equal enjoyment of not only places of public accommodation, but goods, services, facilities, which I think a website's a facility if I'm not wrong, but maybe you have something to say about that. I know it's not a part of the question presented. Privileges, advantages, or accommodations. I mean, shouldn't we be interpreting this as broadly as possible to cover the most, to remedy the most wrongs it can, including for this particular plaintiff below?
2 points in response, Your Honor. First, a website is not a facility because facility is interpreted to be a physical space. And then briefly—
Well, it must mean something different from place of public accommodation, or is it an example of a place of public accommodation? There's an or in paragraph A that makes it disjunctive. I would think it'd be different. Facilities and places of public accommodation would mean two different things then, I think.
Facilities and places of public accommodation should be considered as a collectively similar thing. However, what is more important to, or what petitioners would like to really clarify for this court is that, yes, the ADA has been written as a broad remedial statute, but it is important to ensure that that statute is not overstepped by the bounds of what the statute explicitly says. And if this court is to make a decision on a test to adopt to ensure that there is something adopted today, it should adopt the intangible barrier test because it focuses on the access of a physical store location, which is the focus of the ADA. Additionally, under Section 12182, Section B2A3, it is codified in the statute that businesses are able to have auxiliary aids, and those aids the standard for those aids are effective communication. Neptune has demonstrated effectively on the record on pages 5 and 6 that standard has been met. And ultimately, Respondent has demonstrated nothing to contradict that standard. For example, the customer service line is open from 8 a.m.
Yeah,
to
Ms.
8 p.m.
Brooks, let me ask you, when's the last time you called a customer service line and a live person picked up the phone? I mean, the record isn't clear as to exactly how that is operated, but I think it's fair to say that one can do more business online by clicking than to actually call someone and actually stay online with a phone customer service for perhaps several minutes or maybe even an hour. I mean, you can't equate the two, right?
Justice Kim, you are correct. And that is even more reason why Neptune has provided an effective communication, mode of communication. The customer service line, Neptune took the care to ensure that there were employees, live employees on the other end of the line who were able to answer customers' concerns pertaining to coupon information, customer feedback, store location information, and taking orders. That is all seen in the record on page 5. And if this court adopts the broad nexus, it could also encourage there to be more of a turn to going online and for businesses to not have the resources to provide that extent of aid, but rather have tech responses, which, as Chief Justice, you mentioned, it's not as effective of a mode of communication. Additionally, the effects of the broad nexus test are currently being felt. In 2020, web and video accessibility cases were up almost 25%. And in 2021, there was a 15% increase from 2020. Additionally, in March 2017, Your Honor, I see my time has elapsed. May I briefly conclude?
Yes.
In March of 2017, the University of California, Berkeley pulled almost more than 20,000 audio and video files from its websites to avoid ADA compliance. The fact that a large university is dealing with this issue is even more of a reason why Congress should be able to handle this issue and assess the impact on all parties involved. Thank you, Your Honors.
Thank you. Okay, Respondent?
Mr. Chief Justice, Your Honors, and may it please the court. There are two issues before the court. I will address how websites are places of public accommodation because the term place is deliberately ambiguous and meant to be interpreted in line with the ADA's textually stated purpose, quote, to create a national mandate for the elimination of discrimination against the disabled. My co-counsel will address why, even if this court disagrees, the Nexus test applied by the lower court is supported by the text of Title III and is essential to ensure that blind people can participate in the medium of society in the coming years. Now,
Mr. Gilmer, do you agree with Mr. Vasquez's introduction that we should be focused on the ordinary meaning of the statute?
Yes, Your Honor. In fact, this court should enforce the text of this statute as currently written without a physical location requirement, because physical is nowhere in that statute. And while website isn't included, the statute is drafted broadly enough for it to be implied, as noted by a number of decisions from this court, including PGA Tour versus Martin, SEC versus Joyner, and others. Petitioner is absolutely right that this case is about separation of powers. When Congress passed the ADA, it weighed competing interests and passed a broad and flexible statute to protect the disabled. It's being treated as such, and contrary to what Petitioner says, it's a violation of separation of powers for this court to narrow the ADA just because the internet has arrived. Businesses have begun to leverage the internet for profit and now don't want to pay the cost.
Well, I'm sure no one's accusing anyone of violating the separation of powers here, but I wonder, what year was the ADA enacted, this particular language?
1990, Your Honor.
And where was the internet at that point?
Your Honor, the internet was in its infancy, at its early stages of development.
My wonder is, how did Congress have the internet in mind when it created this language, such that now in 2022, we can say, oh, Congress's intent, which is the only thing I care about, because of course I don't want to violate any separation of powers. I want to just interpret this according to Congress's intent. How could I think that Congress could possibly have intended place to include something that did not yet exist in 1990 in a broad way? Congress
absolutely did not know that the internet would become what it was, that we would have Amazon and we would have Netflix, but it structured 121.81.7, that list of public accommodations, to be flexible enough to capture new innovations through its repeated use of the word other. You see other sales or retail establishments, other places of public gathering. And Justice Kahn, you noted, the First Circuit in Car Parts Distribution Center versus Auto Wholesalers on page 25 of the record, it correctly noted that at least one business, travel service, was already non-physical when the ADA was drafted. So even in 1990, it's unlikely that this sort of physical location requirement was top of mind. Now, before I go any further, I'd like to address three questions of the panel. First, Justice Durkin, you asked what the practical impact of ruling for Petitioner would be, and Petitioner said it would be great. The real practical impact is that every business going forward is going to move online to escape the ADA. Every business is going to shift to supplying out of warehouses to escape the ADA, and the isolation felt by disabled people, which was the entire purpose of passing the ADA, will only accelerate as they are unable to live in a digital world. That's not great for blind people. Second, Justice Costa, you asked whether Congress took on the risk in choosing the words that it did in drafting the ADA. It absolutely did. Congress is responsible for passing the broad statute that it drafted, and to the extent that it isn't working as desired, it is the party to correctly remedy the situation. But currently, this court should implement the current text of the ADA without reading in a physical location requirement, which exists nowhere. And finally, Your Honors, my argument, it really has 3 points. First, the ADA has statements of purpose in the text. Section 12101B, which mandates equality of opportunity with no language regarding what the world looks like. Second, that protectionist purpose plus the expansive list of accommodations, which listed in section 121.81.7, which this court has ruled in PGA Tour versus Martin on page 26, should be construed liberally, illustrate a desire for a flexible statute that captures business innovation.
Is that definition of public accommodation really affecting the word place? I think I've misread the statute as I spoke with, I believe it was Ms. Brooks or perhaps Mr. Vasquez, but I think it was Ms. Brooks, where I distinguished between facilities and place of public accommodation. As I read it, my impression is that the list of, again, in 121.82A, goods, services, facilities, privileges, advantages, or accommodations are all of any place of public accommodation, not distinguished from. And so I wonder if when I look at the definition of public accommodation, it's not defining place, it's defining what kinds of things are public accommodations in case you didn't know. And then place is still undefined in the statute completely. So that when I look at those physical locations of restaurant, motion picture house, et cetera, that those really aren't helping me define the word place in the statute.
Your Honor, public accommodation isn't defining the word place explicitly as much as it is highlighting that this statute was intended to be a broad remedial statute that could capture a number of different business innovations. Place is informed by the section 121.01B purpose statements, which states that the goal of the ADA is to provide a comprehensive mandate for the elimination of discrimination with no physical language requirements or comments on what that world looks like. That plus the 121.81.7 list, which this court has held in PGA Tour versus Martin on page 26, is supposed to be construed liberally, is not an exhaustive list.
Wouldn't you agree that the public accommodation definition in this case only tells me that a candy store is covered as a public accommodation and that's all it's telling me?
Your Honor, I apologize, you cut out. Would you repeat that question?
I'm sorry. Would you agree that the definition of public accommodation in it's 121A2B27, I mean, that's what that's what I have here. That definition of public accommodation is just telling me that a candy store is a public accommodation and nothing more. It's not telling me whether or not a website is a place or the physical plant is a place because it's not defining place. It's just telling me what kind of businesses are public accommodations and not private accommodations.
Yes, Your Honor, it is informing that a candy store is a public accommodation, regardless of whether or not that store is online or in a physical location. There's no language distinguishing the two. And when we think about that just from a plain meaning perspective, the plain meaning of place doesn't have a clear physical location requirement. 2 months ago, 60,000 people attended a Foo Fighters Super Bowl concert in the Facebook metaverse. A website, a concert hall is a place of public accommodation. This court in Reno versus ACLU described the web as, quote, a sprawling mall of goods and services. Malls are places of public accommodation. Today,
we didn't, when in those cases you're noting though, we weren't interpreting the ADA, correct? You're just plucking out language from cases where we described the web, but those were not in the context of interpreting the ADA statute.
Your Honor, they are not. However, they do describe how our view of the term place has changed. However, if you want to even look at it from a historical perspective, when this
I'm sorry, I hate to interrupt. You used the term flexible statute earlier. Isn't that exactly what Congress doesn't want us to do? We're not supposed to turn statutes into flexible pieces of legislation. We're supposed to interpret them based on the language contained in them. When it's flexible, that means we start deciding what it means. That phrase struck me when you said that.
Your Honor, this court is not supposed to turn statutes into flexible law. However, Congress has the ability to pass remedial statutes that are flexible and ambiguous, and this court is recognized as such in Massachusetts versus EPA, in Pennsylvania Department of Corrections versus Yeski, where
Well,
this
then how do you respond? And then how do you respond to petitioner's argument that Congress had the chance when the internet was very fulsome not long ago to change the statute to make explicit that websites are covered under the ADA?
Well, in fact, Your Honor, petitioner ignores what Congress did in that 2008 ADA amendment. Congress, in fact, intervened to maintain the ADA's broad and flexible language after this court narrowed it and excluded discrete groups of disabled people. In that amendment, Congress stated in its findings that it was, quote, rejecting requirements enunciated by this court in Toyota versus Williams and Sutton versus United Airlines, which removed protections for large numbers of mainly non-physically disabled people by narrowing the definition of disability. And Congress didn't accept this court excluding.
Where were those findings? Were those part of a piece of legislation that was voted on by the full Congress and adopted by a majority?
Yes, Your Honor, that is in section 12-102-4A of the ADA Amendment Act of 2008. And in those findings further, Congress, because it didn't accept this court excluding groups of individuals, it stated, quote, that the definition of disability should be construed in favor of broad coverage of individuals under this act. So if this court narrows the definition of public accommodation to exclude another insular group of disabled individuals, it will now be in direct opposition to Congress's demonstrated intent, and where this court has acknowledged that there's a right and a need to pass open-ended statutes to ensure flexibility and forestall obsolescence, it needs to be willing to recognize them as such. Now, I'd like to take a second to discuss petitioner's argument about this whole idea that because the Department of Justice hasn't passed a rule that there can be no clarity. Agencies don't have to pass specific rules for statutes to have weight. That would completely undermine the legislature's ability to facilitate change.
I thought what they were saying is that the Department of Justice passed a regulation that defined place of public accommodation, and that we should not hand down a decision that contradicts that regulation if it is a reasonable interpretation of the words place of public accommodation. What do you say to that?
Your Honor, in those, the Department of Justice accommodations, which opine on the 36.104 Department of Justice regulations, they do not define public accommodation as a physical location. They talk about facility, and those regulations haven't provided clarity, so much so that in 2018 and re-articulated 3 weeks ago, actually, Congress wrote to the DOJ asking them to clarify whether Title III and the whether or not websites fell under Title III. And the Department of Justice said yes. In fact, it doubled down on its position 3 weeks ago on March 18th, issuing another guidance stating that quote, inaccessible web content means that people with disabilities are denied equal access to accommodations online. There's also in that new guidance language that says, quote, much like improper ramps and doors create barriers from entering a building, which is a place, similarly poor screen reader capability limits access to accommodations provided online. So the DOJ—
What weight do we give to guidance from the Department of Justice that is not enacted in an actual regulation?
It's only entitled to Skidmore deference. However, it should be, in Skidmore deference is persuasive deference. There's no mandatory authority there. However, it should be noted that these Skidmore deference statements are being used to clarify a regulation that is entitled to Chevron deference. And so that Chevron deference—
What would you say of the cynical view that the Attorney General for the next administration may change their mind about that guidance?
Then the Department of Justice has every right to do so, but until it does—
what weight do we give guidance like that in the courts when our decision is going to be binding?
Your Honor, only to the extent that it can be used to provide clarity. It should be given persuasive deference, and only really to say that facility is still very much a hotly debated subject and is not a pure physical location requirement.
I don't mean to get into semantics, but I realize we keep on using the word deference for Skidmore or other persuasive kind of— wouldn't you agree that deference that is not truly deferential is no deference at all, that it's just persuasive? Should we clarify that in this decision?
No, Your Honor, that's not necessary because the broad language of the statute already informs a flexible definition of place. And my final point before I go is that this petitioner relies on canons to read in a physical location requirement, but this court has said in 3 cases, SEC versus Joyner, US versus Alpers, and US versus American Trucking, that canons are subordinate to the doctrine that courts will construe and act in conformity with its dominating purpose. Courts don't use canons to create loopholes.
Before we get to purpose, we get to plain language first, before I even need to get to the purpose of the statute, right?
Mr. Chief Justice, I see that my time is getting ready to expire. May I answer Justice Costa's question and briefly conclude? Apologies, Justice Costa, you cut out a little bit. Could you?
No, that's you mentioned that we should look at the purpose, and I just wanted to clarify that you agreed, if you do, that we should look to the plain language of the statute first, and if the question's not answered by the plain language, then we look to the purpose, not before.
Yes, Your Honor, this court should look to the plain language, and the purpose of the ADA is stated in the text in section 12101B, which informs the rest of the statute. And so as such, this court should find that websites are places of public accommodation and affirm the 13th Circuit's denial of summary judgment. Thank you.
Thank you. Mr. Brown?
Mr. Chief Justice, and may it please the court. I will be addressing the second issue, which is that even if this court holds that websites are not places under the ADA, when a website facilitates the use of, purchase of, and enjoyment of goods, services, and privileges of a place of public accommodation, that website is subject to the ADA's accessibility requirements under an appropriate broad nexus doctrine. However,
Mr. Brown, I have a question on this right at the start. And this is, I know I asked Ms. Brooks the practical implications of a broad interpretation. And she talked about the cost of it, and Justice Costa pointed out that's really not our concern. That's something the legislature needs to weigh. But what about the practical impact on the district court judges and the appellate courts that have to interpret whether or not a website is connected enough to a physical facility to allow for that nexus test to take place? Isn't that going to involve a huge amount of interpretation by district court judges around the country?
Perhaps, Your Honor. However, Congress has already balanced these considerations with judicial administration, with accessibility online, and with business interests by passing the ADA itself and using broad language to encompass swaths of discrimination across the United States. They passed this language to protect those in their accessibility in the goods, services, and privileges of places of public accommodation.
Is there somewhere in the legislative history, loath that I am to look at legislative history, where we can tell in the record that Congress actually considered that particular issue that Justice Durkin just raised about the difficulty of administering such a rule?
No, Your Honor. However, the plain meaning and the plain text includes the word of and the services of a place of public accommodation. And there's no need to look at the intent. As you mentioned, Justice Costa, there are some troubles with looking at intent in some cases.
You mean the legislative history, I'm sure. I mean,
yes,
intent is
legislative.
The actual ultimate issue. I see what you mean. I understand. My only question is, so did our decision in Shelby County, which required, I think, Congress to have a record in order to reenact the Voting Rights Act by an overwhelming majority, if I remember our reasoning there correctly, does that mean that we require Congress to show us we require litigants to show us in every congressional record of every statute when we interpret it that Congress actually thought about the concerns we have as well?
Not in this case, Your Honor, because the ADA is meant to be flexible. And as the court in Gorecki versus Hobby Lobby noted, the ADA is meant to adapt with the times and cover new services, goods, and privileges that may accompany technological advances. Ms. Albert is one of 12 million visually impaired individuals in the United States and one of 60 million disabled individuals in the United States who seeks to be covered and have the full and equal enjoyment of goods and services in places of public accommodation. Petitioner, as a preliminary matter, petitioner relies heavily on the auxiliary aid requirement and the effective communication. However, the Eighth Circuit in Childress versus Fox Associates has noted that whether auxiliary aids result in effective communication is an affirmative defense, and failure to raise that affirmative defense at the trial court level indicates that this issue is waived. The 13th Circuit noted this on page 23 of the record, that whether this effective communication is resulting from the auxiliary aid was not raised on the motion for summary judgment, and thus that argument's waived. And at the very least, this court should remand to the district court for additional fact-finding on the effectiveness of the auxiliary aid itself. And this is why this court should affirm the denial of summary judgment. First, because the 13th Circuit was correct in applying this broad nexus doctrine, and second, because under any approach, whether it be narrow, moderate, or broad, there is still a genuine issue of material fact about the accessibility of Neptune.shop.
Let me ask you, Mr. Brown, I understand your argument is really an alternative argument, right? Because you in fact consider websites to be places of public accommodation. And you talked about services of a public accommodation, places of public accommodation. But what is the service of Westridge store?
Well, Your Honor, services can encompass a number of things, and the services in this case, page 4 of the record indicates that there was a store locator online. Page 4 of the record indicates that nutrition and allergen information were available online. And page 5 indicates that there were coupons that Ms. Albert was unable to access for use at the physical store.
But is that the service of Westridge store, or is the service simply selling candy?
If this court decides it's not a service of the store, it's at very least a privilege of the store. And as the Ninth Circuit held in Robles versus Domino's Pizza, anytime a website eases the purchase, eases the enjoyment of those goods and services, they must be made accessible under the ADA, as the ADA is explicit in that it prohibits discrimination on the basis in the full and equal enjoyment of goods and services of places of public accommodation. And Justice Durkin, you noted some concern with the phrase flexible statute. That's not respondents' words, that's the Department of Justice's words when they implemented the final rule on non-discrimination when enacting the auxiliary aids requirement under 36303C. They intended this to be a flexible way. As petitioner points out, the number of public accommodations is around 54 and may encompass a broader number. And having a one-size-fits-all solution and technical standards is not appropriate in these cases because businesses have different factors that require them to comply with the law. The auxiliary aids in 36303 includes a number of factors for the courts to look at, including financial resources of the company, financial resources of the parent, geographic location, technological assistance, and these are intensive fact questions that must be addressed at the trial court level and not addressed.
In the statute itself, one of the considerations is whether the accommodation would result in an undue burden. Was there any development of that at the trial court level?
No, Your Honor, none of those undue burden statutes under 28 CFR 36104 were developed. And the petitioner is free to make those arguments at the trial court level to develop those facts and allow for proper arguments and fact finding. And the key point of this case is that the broad nexus doctrine aligns with the text of the ADA and provides clear standards for compliance. The intangible barriers approach narrowly reads into a physical access requirement when the broad language of the statute itself is the prohibition in the services of. Chief Justice Kim, you pointed out that the in-person experience may be very different from the online experience. And that's exactly what's happening in this case here. as Ms. Albert was forced to use a customer service line to receive some of the information that would be online. That's available for less than half the time over the course of a year as the website itself.
But you have to argue that that's an unreasonable accommodation, and I would assume that if you're telling us that there has to be a nexus between the website and the store, if I understand that that's what you're asking us to find, then you don't want to say that the website is really a different experience than the store. Perhaps I'm a little confused.
Justice Costa, the point that I'm trying to get at is that there's intensive fact finding that needs to be done at the lower court, and that there is a broad nexus here because the website itself is a service of the store. So first, there's a threshold question of whether Title III applies through the broad nexus doctrine, and then more intensive fact questions over whether there's an undue burden or auxiliary aids. But under the broad nexus doctrine, there is a connection between the store.
May I ask, procedurally, you've not moved for summary judgment as well, am I right?
Correct, Your Honor.
All right.
And petitioner focuses on the facts that the orders were fulfilled from a store, but neglects to look at the facts on page 3 of the record, which shows Ms. Albert consistently used Neptune.shop to pre-shop and plan for her in-store visits. And page 5 of the record demonstrates that Ms. Albert was prohibited from using and downloading coupons for available at Neptune's physical store due to the incompatibility with her screen reader. Justice Costa, you asked about, it looks like that Congress wants this to be read broadly, and that was through their explicit choice of language. As the Ninth Circuit noted in Robles versus Domino's Pizza, this is not limited to in or at a place of public accommodation. Chief Justice Kim, you noted that Congress can choose terms if they want to, and here Congress chose of, which is a broad statute, which is a broad word read into the statute in itself. And this aligns with this court's holding in Cherepin versus Knight, which finds it's a familiar canon of statutory construction that remedial legislation should be construed broadly to effectuate congressional purposes.
It's just difficult because in the Bostick case where we found that Congress, when it said sex, meaning gender, we were interpreting the statute to still use the same meaning of the word gender, just the implication of it led to perhaps a different right for a different purpose with regard to sexual orientation and transgender, but it did not protect sexual orientation. It did not protect transgender per se. It's just that when those things are inextricably tied to one's gender, but we were still interpreting sex in the statute, that word, to mean gender. Here, place, it just doesn't feel like Congress in 1990 would have said to itself, place must mean website too. Whereas in 1964, whenever the Title VII was written, Congress was thinking gender means gender, sex means gender as we think of it today. Do you see the distinction there?
Yes, Your Honor, and the term place, as my co-counsel mentioned, should be read broadly as well. As determining for the nexus test, the focus is on
my question is, how can you convince me that that was Congress's intent at the time in 1990 that they could have contemplated this?
Under the nexus test, there's just the focus on the term services of, and the services are meant to be read broadly and adapt with the changing times overall. So while place, even if it's read narrowly to only include physical locations, under a broad nexus test, that website is a service or privilege of, because it eases the purchase and use of goods and must result in the full and equal enjoyment of goods and services in the provision of those goods and services of a place of public accommodation. Page 21 of the record shows the 13th Circuit noted that websites are an integral part of a business's communication, advertising, and marketing and sales efforts. The pervasiveness of the internet today has changed the marketplace of services, and the broad nexus test gives businesses direction on when they're covered under Title III and also achieves Congress's written intent in riveting discrimination against individuals. This aligns.
It gives them direction by saying they're always covered under Title III.
Yes, Your Honor, if there's a connection to a physical place of public accommodation.
Which there almost always is, because there's occasionally some websites that just sell completely by the internet, but Target, Macy's, and this entity itself all have some physical location. We're talking about the majority of businesses have an internet connection now, an internet presence, and a physical presence, which means what your interpretation is, every one of those websites has to be ADA accessible.
Precisely, Your Honor, and that's the reason why Congress chose to pass the ADA itself. When the ADA was first passed, it covered every brick and mortar store that was open to the public.
How many websites did it cover when it was passed?
I do not have that information, Justice Costa. I apologize.
Would you be surprised that it covered any?
When the ADA was first passed in
1990.
It may have been, depending on when the internet first came about and the first websites there.
Would the rule you're promoting say that Amazon, which I understand has no brick and mortar stores that, well, I guess they do now, but when they first began, they didn't. They would not have at the time when they first began been required to provide an accommodation that would comply with the ADA. But this candy store or Macy's or Target, their competitors would, such that that Congress might have in fact encouraged people to go purely online and close down their stores, fire all those employees in the stores, et cetera.
Yes, Your Honor. Chief Justice Kim, I see my time is running low. May I answer Justice Costa's question?
Go ahead.
Thank you. Your Honor, Justice Costa, this is meant to cover as many individuals as possible to remedy discrimination. The ADA bars discrimination completely. There's no percentage allowance. And whether it may cover less than if this court finds that websites are physical or places are physical, the broad nexus test still does a better job and is more appropriate than a narrow intangible barriers test, which improperly focuses on physical access. And it is for these reasons, this court should affirm the 13th Circuit and its denial of summary judgment. Thank you.
Thank you, Mr. Brown. Petitioner? Rebuttal?
Your Honors, a few points on rebuttal. To respondents' first issue, respondents concede that there should be a focus on the ordinary meaning of the statute, and there should be an enforcement of the language as it is written. It would have been simple to include words like website, forum, platform, or feed within the statute. However, Congress—
Would it have been in 1990?
I'm sorry, Your Honor.
Would it have been easy to include the words website, forum, et cetera, in 1990? Were those known terms at that time?
They may not have been known in 1990, but they were known in 2008 when Congress ratified the statute. And ultimately, as Your Honor, Justice Costa mentioned, before anything, the court looks at the plain language. And here, the statute is clear, the text is king.
Well, then, can you go ahead and respond to Mr. Ilmer's clarification that in 2008, Congress did issue findings that Congress did, in fact, mean to have expansive definition for place?
Ultimately, even if Congress did decide that there should potentially be an expansive definition, which is currently being addressed through HR 1100, which is more reason why this issue should be turned to Congress. It demonstrates that it is an important issue. Petitioners want to make clear this issue is one that should be handled, but it should be handled assessing all parties involved. Additionally, Section 12182, Section B2A3 establishes that the aid requirement is an extension of Title III's compliance, not an affirmative defense. And that was supported by National Association of the Deaf versus Harvard and McGann versus Cinemark. Additionally, once again, respondents place nothing in the record to indicate that the customer service line was not effective. Thank you, Your Honors.
Thank you, Ms. Brooks. Okay, court's now in recess. We will confer and then we will return. Thank you.
Thank you, Your Honors.
Okay, judges, you should get a pop-up invite to the judges' orientation room, and if you'll accept, that will take you to your conference room.
Well done, team 257.
Great job, guys.
Kudos to both of you, team 342.
we submitted our votes, and I think they're tallying the votes. And in the meantime, we will share with you some of our thoughts as you, I don't know whether there are other moot court competitions you are engaged in, but certainly our comments might be helpful as you go into the real world and practicing law and litigating. So we'll start with Judge Costa, Judge Durbin, and then I'll say whatever's not covered by the other two judges. We will try not to repeat the same comments for efficiency's sake. Judge Costa?
Thank you, Judge Kim. I must say that I don't know that I have any comments off that I could really give you. I'd be interested to hear from the other two judges myself. I don't generally like to just give people kudos at these competitions because I think that you really much would rather have comments that help you in the next round usually, but this being the championship. I'll just tell you, I thought that responses to questions were very good, that people seemed like they were prepared with responses. I'll say sometimes it surprised me how well people had anticipated a question that I don't think was part of their main argument, but came up. I know that Ms. Brooks did that a couple of times by saying, well, I have two reasons for that. And she was answering the question, not just off the top of her head, but as though she had completely anticipated that question and prepared a response to it. I'm sorry I did not write down the example of it. But that's, so I regret that all I have are good things to say in that regard. And that's really, really it. I think the most important thing when you're doing moot court, when you're doing appellate argument, is to have an answer for every question. That's step one. Step two is having a good answer for every question. And the way that you do that by preparing, of course, is just standing in a room, the way I've done it, and asking everyone in your office, if that's where you're working, to come in and just feel free to ask you questions throughout the day, and you stand there all day basically answering questions before you mute an appellate argument. That's what we've done in my experience that I found to be most helpful. Anyway, so congratulations, and I just won't take up any more of your time. Thank you, Judge Kim.
Judge Durkin?
Thank you. Well, terrific job, everyone. I'm a district court judge in Chicago, so I hear a lot of oral arguments. I've sat by designation up in the Seventh Circuit, the appellate court for Chicago and other states, obviously. And your arguments compare favorably, and in fact, exceed the level of competence of the attorneys that argued in front of me when I'm in the Seventh Circuit. Now, to be fair, you've concentrated on this problem for an entire semester or whatever period of time you have. Private practitioners don't have that luxury. They can't spend 6 months preparing, or 4 months, or even a month preparing for an argument, typically. So you have the advantage of time. But your poise, your knowledge of the record, your ability to answer questions, your ability to stay on track even when interrupted intentionally by all of us, because you will find that judges are often rude in the sense that they want to get their questions in and they'll interrupt you. And the ability to stay on task, respond to the question and go back where you left off is a real talent. And I thought you all exhibited that. I thought that you all did good jobs on, I think Ms. Brooks, I gave you a layup, which is, what is the practical impact if we find for the other side? And you launched into what I view as a very practical issue of what does this mean? I think the Supreme Court and most courts want to know what the practical implications of a decision are. For me, at the district court level, they rarely go beyond the parties. But at the Supreme Court, they apply across the nation. So it's important to be able to respond as you did to what the practical impact of the ruling would be. That's why I asked, I think it was Mr. Brown, what would happen to poor district judges like me, where I'd have to interpret whether or not a particular aspect of a website is implicated by the physical location that is being serviced, which I thought, and I still think would be a very difficult job for a district court judge, not just in the actual analysis, but the number of times this could come up, especially with testers. But my notes on all of this is each one of you did a good job responding to questions. I think you both had an ability. Remember, you want to live for another day. So if a court asks, what should we do? One suggestion, which I think both of you at one point or other made, was remand for further facts. If you don't think it's going well for you at the level you're arguing, ask for a remand, which is not a full win, but is also gives you the ability to live for another day. And courts sometimes want to do that. If you can point to facts that weren't developed at the district court level that need to be, like the undue burden issue, which I think is what I asked Mr. Brown, and he pointed out that going back to the district court to deal with undue burden would be a good way to address the issues that petitioner raised about the vast implications of a broad ruling that affirms the 13th Circuit. So keep that in mind as you go forward as advocates when you go out in private practice. Sometimes a full win may not be possible, but it's almost a full win if you get a remand, because you get another shot in front of another judge, and you may be able to develop facts. You may be able to settle. There's a variety of things that may help you win for your client one way or the other. I thought the language, I thought it was a good back and forth about the 2008 update to the statute, and a good response by respondents about why that isn't necessarily a slam dunk for the petitioners. That's about all I had. One point I'd make to all of you, I didn't know this until I sat up in the Seventh Circuit. And maybe you knew this, but I didn't until I was up there, is the cases, typically a panel of appellate judges will hear 6 arguments, 6 different cases, then they go back and leave the bench. They decide the case typically at that moment, right after they get off the bench. They sit at a table, and the lead judge, whoever's senior, typically the judge sitting in the middle of a 3-judge panel, will ask the junior member, which was always me because I sat by designation, would you vote to affirm or reverse? And I'd say what I wanted to do and briefly give my reasons. Then the next judge would do it, and then the final judge would do it. And then the senior judge among the group would assign the opinion. The decision's made. Now, certainly they can change their mind later, but I want to state this because of the importance of oral argument. The judges decide whether to affirm or reverse right after that oral argument, typically. They can change their mind later. And I'm not sure the Supreme Court works the same way. I think they may work a little bit differently. I don't have that experience. But when you're arguing before a court of appeals, at least in the federal courts, or at least in the Seventh Circuit, the case gets decided typically right after the oral argument. There's a lot of work up front with bench briefs and bench memos, and a lot of the research is done by the judges and by their law clerks up front. So they have some tentative ideas. But those questions are important because it often may be decisive on which way a judge may go. So I just point that out as you go forward in your career. Don't underestimate the importance of oral argument, because it is like a closing argument in front of the jury. The jury goes back and deliberates right after the last argument. The appellate judges decide the case typically right after the oral argument. Then they go off and write the opinion. It's not a matter of the opinion coming out 6 months later that they mulled on it for 6 months. They decided it right after the argument, and then the judge who's assigned the opinion takes 6 months to write it and circulate it to the other judges and make sure it's represents the majority view. Thank you.
So for me, I think that both teams were coached really, really well. You all argued like veteran attorneys, and Judge Dirk and I are in the same district, Northern District of Illinois in Chicago. I am one of the magistrate judges. So at a trial court level, I am below Judge Durkin. In the appellate level, you have the circuit judges, and then you have the Supreme Court on top. So I also hear many oral arguments in my courtroom pertaining to various motions and whatnot. And we also have hearings, evidentiary hearings. So I have seen many attorneys argue before me, and I can say without reservation that all 4 of you did just as well or even better than some of the attorneys that have appeared. And I really don't have to say this to you, so it's not like I'm just trying to be nice about it. You really did do an excellent job. And I think that you should really thank your coaches, because I'm sure they had a lot to do with how you presented yourselves in oral arguments. So I actually asked Professor Larry Bates whether we had to pick a winner, but it is what it is. And we had to give one number over to the organizers to select a winner. But in my opinion, this probably was the closest championship round I've judged. And I have been with this particular conference, this competition for a number of years. I want to say maybe since 2011. All four of you did an amazing job of stopping where you were to listen to the questions and to actually answer those questions. I can't tell you how often in my courtroom, I'll stop an attorney to ask a question. Sometimes they just don't understand what I asked and they go on to something different. But during that time, I am distracted because I'm not getting an answer. So you're not really doing your client any good by moving forward with your arguments without answering a question. And the four of you did an excellent job of pausing, listening, and answering. So I really commend you for that very difficult skill, in my opinion. And so I've done many Zoom competitions, and this is the first time that all four of you had great eye contact. It's really hard to do when you are doing a video conferencing or video competition to really look like you're actually looking at the listener. And the four of you somehow did a terrific job. I don't know whether you taped something onto the camera or something, but I noticed that right away, that I felt like you were really listening, looking at me and talking to me. So again, that's also very helpful because who knows, maybe more and more judges will keep doing these video conferencing and video hearings moving forward. So that certainly is a skill set that you want to preserve, even if we go back to normal life. And one thing I do want to say about Ms. Brown, because you did have the privilege of doing a rebuttal, and I thought your rebuttal was excellent, because you really do want to come out swinging and not simply regurgitate what you've argued in the past. Rebuttal portion is really to rebut, and you did a great job doing that. Mr. Brown, one thing that I liked about your, particularly about your argument, is that you hammered on the standard of summary judgment. And as a practicing lawyer, you always want to keep in mind what the standard of review is and try to get at the lowest hanging fruit. And in summary judgment motions on appeal, it's really trying to hammer away the fact that there are factual disputes. The case should go back down for factual development so that you keep hammering that away. And I think that was very effective. So those are the comments that I have for the four of you. And again, I can't stress this enough that this was really, really close. And it's unfortunate that we had to give one team number over the other. Thank you all for giving us the privilege of listening to you this morning.
I would add too, if the professor who prepared this problem is on the line, this was a terrific problem. It really was well written, well briefed. I find it very interesting, and it's going to help me in my job, my real job. So I thought it was just terrific. Whoever prepared that, if they're on, my congratulations.
Thank you all for volunteering today.
Thank you.
Appreciate it.
Thank you for sharing your time.
We appreciate the comments, judges. Thank you.
Can we get
She is not online, but I will.
For the schools at this point?
Yes, you can tell. Yes.
We can announce it to them.
You can tell them where you were from. Yes.
Pierce, Ilmer, and I are both from Southern Methodist University in Dallas, Texas.
Elliott and I are from UC Hastings in San Francisco, California.
Well, your schools ought to be very proud of you.